Hello, everyone, and welcome. Thank you for joining us in today's panel webinar, Employee Legal Rights During COVID-19. My name is Yusra Benjeloun, Administrative Coordinator and Project Manager with the Work Wellness Institute, and I'll be co-moderating today's webinar. We would like to thank our academic team and our 9 founding partner organizations in the Harnessing Talent project. Harnessing Talent, Alliance for Recruiting and Retaining Canadians with Disabilities and Mental Health Challenges, is a 3-year project funded by Employment and Social Development Canada. This webinar is made possible through the support of ESDC, as well as donations and memberships to WWI. We thank our advisory committee and speakers who contribute to this webinar series. Today, we're extremely happy to welcome our panelists, Dr. Kelly Williams-Witt and Simon Kent, and our co-moderator, Maureen Han. Maureen has been the President and CEO of the Canadian Council on Rehabilitation and Work, CCRW, since 2012. CCRW is the only national organization with the sole vision of equitable and meaningful employment for people with disabilities in operation for over 40 years. Under Maureen's leadership, CCRW has seen an increase in direct program service throughout Canada, as well as a more transparent streamlining of understanding the business case of hiring a person with a disability. Maureen has been very active in the cross-disability sector, currently focusing on employment issues. She has been involved with numerous committees and groups that increase awareness and access for the disability sector and the deaf community. Maureen, it's a pleasure to co-moderate with you once again. The floor is yours.
Thank you so much, Yusra. So, and thank you very much for having me back again today. I appreciate these sessions very much, and I look forward to hearing today's session as well. So, I'm pleased to introduce you to our 2 panelists for today. Dr. Kelly Williams-Witt is a professor and associate dean of the Dillon School for Business at the University of Lethbridge. She is a labor arbitrator and former registered nurse with an MBA and PhD in human resource management and labor relations. Prior to taking on her role as an associate dean, Dr. Williams-Witt taught courses in labor relations, labor and employment law, human resources management, and workplace health management. She is an active researcher in occupational health and return to work after illness or injury. Her work is published in peer-reviewed scientific journals, and she has authored numerous books and book chapters on work disability and labor and employment law. Dr. Williams-Witt is the chair of the Canadian Industrial Relations Association, the CIRA, Southern Alberta chapter, and former president of CIRA National. She holds an appointment with the Federal Mediation and Conciliation Service as an adjudicator for cases following the Canadian Labour Code. She sits on the editorial board of the Journal of Occupational Rehabilitation and is a member of the board of directors of the Workplace Wellness Institute. And lovely to meet you, Kelly. Simon Kent is our other panelist today. With over 20 years of hands-on legal experience and a bold entrepreneurial spirit, Simon Kent is a visionary committed to redefining the practice of employment law. He is a keen advocate for legal innovation, working to reimagine the employment relationship as a reciprocal one rather than a binary arrangement that benefits all workplace stakeholders. A veteran practitioner, Simon advises senior executives and company leaders. He is a creative and strategic thinker with a unique skill for solving the most complicated workplace puzzles, and is the counselor of choice for employers and employees looking for cutting-edge solutions to legal complex problems. In 2019, he directed his energy to exploring alternative pricing strategies as one way to provide value to his clients. You can read more about that value focus in a link that we will provide to you. The founder, heart and soul of Kent Employment Law, Simon has led his team to break ground and become the first B Corp certified law firm in Canada in 2015. He is a thought leader in the employment law space as an event organizer, author, media commentator, and public speaker. Simon has also been recognized by three best rated as one of the top 3 employment lawyers in Vancouver, and recently shared his thoughts on the challenges facing law firm managing partners with CBA National Magazine. So it's my pleasure to spend the next little while with the two of you, and I believe, Kelly, you're going to start.
I am. Thank you so much, Maureen and Yusra, and welcome everybody. We're looking forward to our session today. I, started creating with Simon the PowerPoint presentation that's in front of you, and the slide that that we're starting with has just a pile of numbers on it, because I feel like that's what everybody's been doing for the last year. We've all been looking at numbers, the case numbers, the counts of people who have been hospitalized. We've just been constantly, the new variant numbers. So we've constantly been checking numbers. And I thought that was really suitable for any conversation around COVID-19. So let's get started then. Who thought a year ago that we would come out of a doctor's office cheering because we had the severe flu and because we found out it wasn't COVID? I think that talks a lot, or speaks a lot to how our world has changed in the last year. We've had a lot of change that has affected employment. It's affected jobs for people. It's affected the way that organizations operate. We've had changes that are related to the vaccine. It's a horrible, uncomfortable process to get tested to see whether or not you've test positive for COVID. So, we're going to be addressing today all of those things that are tied to COVID that actually tend to affect the workplace, and the issues that we've seen coming up in labor and employment law. So some of those things, of course, are around workplace safety, new uses of equipment that people didn't have to wear before. Is it safe to come to work? People are working differently, people working from home. Mandatory testing or not mandatory testing, mandatory vaccinations. There are lots of questions around whether or not that can be done, whether or not employers can require it or should require it. Personal protective equipment, what people wear at work, whether employers are providing what's necessary. What happens when an employee isn't following the new protocols around COVID? So what happens with respect to discipline? Human rights issues are at play here as well. So things around accommodation of people with other types of illness or injuries, factors around this discrimination that's related to people who might be diagnosed with having had COVID. And then, of course, there are all the issues around work absence and pay. So we're going to be touching on all of those today. And because we understand that the folks that are in this room today listening to this, and those who will listen to it later, are from a really broad variety of backgrounds. We're going to start by laying a foundation of sort of some basics of the legislation and law that matters or that affects how workplaces and employees can respond when they're faced with issues around COVID-19. So with that, I'm going to move on to our next slide. So the legislation that we'll be touching on today is really related to that health and safety piece in the workplace. So typically that includes occupational health and safety acts, regulations, codes, and standards. And each province has its own occupational health and safety set of legislation. And that each province is different, slightly different, but there are some real similarities, and that's where we're really going to focus most of our discussion today, is on what is kind of common across different provinces. And then, of course, if you have an organization that falls in the federal sector, so that's typically banking, telecommunications, transportation, and those are covered by the Canada Labour Code and the Occupational Health and Safety section of the Canada Labour Code. Another piece of legislation that typically gets, I guess, some interest around COVID is workers' compensation. When are workers compensable for if they've contracted COVID-19? Human rights legislation, absolutely. The concepts of accommodation for people for wearing masks, accommodation for family status if someone has a family member who is high risk for contracting COVID. Collective agreements. So those of you who work in unionized environments know that that's probably one of the first places that you need to look at to see if there is anything in your collective agreement that you might need to turn to in terms of how you are approaching COVID in the workplace. So if you have joint workplace health and safety committees, those might be addressed within collective agreements, and their role in terms of creating policy and procedure is something that you might want to be looking at as you move through that process if you're on the employer side or the union side. So making sure that there's collaboration there. As I said, it's really important for you to know, if you are an employer or an employee, what jurisdiction you actually fall under. So workers' compensation, occupational health and safety, and human rights legislation is all very provincially dependent. So you need to know whether or not you fall under Alberta's legislation, British Columbia's legislation, Ontario's, or perhaps the federal legislation. So knowing where to look and understanding what jurisdiction, that helps out quite a bit as well. So as I said, we're going to focus primarily on those kind of common consistencies across different types of legislation. So before we jump in any deeper, we're going to have a quick poll. And I believe Yusra is going to run this for us, and we are going to have you answer a question. Have employees in your workplace resisted wearing protective equipment like masks or following COVID safety protocols? So they're going to enable that poll, and we'll give folks a few seconds here, a few minutes to respond to the poll. Do we have results just yet?
Okay, we've got the results. So I'll read them out if that's okay. So 45% have said this has happened a few times. 32% this has not happened at all. 18% I'm not sure, and 5% this has happened a lot.
So it's interesting to know how many times people have encountered this in their workplaces. And I think that that's why this is such a timely kind of a conversation that we're having today, because there are issues that arise around that. Sometimes, not all the time, but for some workplaces, I think that there's a greater level of resistance. In some workplaces, there is a lower level of resistance to some of the changes that have occurred. We don't know why, but sometimes that's what's happening. Okay, so let's talk then a little bit about general occupational health and safety. So most occupational health and safety legislation, really the focus is on prevention. So we are trying to put in policies that will protect workers and try and prevent injuries and illnesses from occurring in the first place. Okay, so the focus for occupational health and safety legislation is really, as I said, on that preventive piece, trying to encourage employers and employees to focus on that and create policies and procedures to prevent illness or injury in the first place. So the legislation typically establishes the rights and responsibilities of the parties, and it's a shared responsibility. So that means that employers have certain level of responsibilities, but so do employees. In this particular conversation today, I'm focusing more on the responsibility of the employer, but I will mention what the employee responsibilities are as well. So some of the key things here are that there is personal liability for employers, supervisors, and employees for their failure to adhere to occupational health and safety legislation. So that's an important thing for people to understand, and for employees to understand that they can also be held liable, and that there is actually criminal liability. And you're in Alberta here. That's where I live. The Cargill food plant is likely to be one of the cases around COVID that there's an investigation ongoing right now with respect to criminal liability there, or the potential for it. So it's live. There aren't any answers just yet around that piece, but it is. I think we're expecting to see some lawsuits or some complaints certainly filed around occupational health and safety. So in terms of worker rights, the key rights that are established in all occupational health and safety legislation, no matter what jurisdiction you're in, is the right for employees to be able to participate in the health and safety process, in developing policies and procedures, in identifying risks in the workplace, and then also the right to refuse dangerous work. And this is probably where we see the greatest impact of COVID. So employees do have the right to refuse dangerous work, but they only have that right when there is reasonable cause to believe there is imminent danger in the workplace. And so we're going to talk a little bit more about that, and Simon's going to answer some questions around that once we move forward. And then the third right that workers really have is the right to know about potential hazards. So all of the systems that are in place in any particular workplace are geared towards protecting these rights of employees and workers. The employer, on the other side, has a responsibility to make sure that workers are aware of the hazards that are associated with their occupations, to ensure they know what duties they have and what their rights are. So posting occupational health and safety legislation where it's visible, WHMIS, workplace health material safety data sheets, and those kinds of things have to be available. So that's really standard operating procedure for a lot of different workplaces. And each workplace is unique in terms of the kinds of hazards that are there and the kinds of information that needs to be made available to the workers. And it's occupation dependent as well. What a janitorial worker might need to know in a hospital is quite different, obviously, than what a healthcare worker, nurse, or doctor might need to know, and what risks they might be exposed to. So the employer is also responsible for creating those policies and procedures and providing personal protective equipment if it's required. They are also required to provide information and training as well as supervision, particularly where the risks are higher. Violence prevention is another responsibility for employers, and I think that this is coming up as an issue around COVID as well, because we are seeing concerns where perhaps customers are reacting negatively to employees who are asking them or requiring them to wear personal protective equipment when they are objecting to it. And so employers are having to attend to that concept or that idea of how they prevent violence in those kinds of circumstances. So training employees becomes particularly important there as well. Employers are required to cooperate with occupational health and safety officers if a complaint is filed or if there's a work refusal. That's part of the role of the employer, and maintaining records, of course, and then reporting illness or injury. So reporting any kind of an outbreak of an illness would also be required of the employer. There's a COVID-related a certain number of cases, and I believe it's 5. At least in Alberta, I think it's 5 cases that counts as an outbreak. So that might be different for each different province. So the key, I think, for employers when they're thinking about occupational health and safety is the idea of doing your due diligence. Right, so we call it the Due Diligence Defense, and this is just these are a couple of sections from Alberta and BC legislation that address the idea of due diligence. So in Alberta, it's the employer isn't expected to be perfect. They aren't expected to protect employees from absolutely every possible risk that there is, but they are expected to do it to the point that it's reasonably practicable. How's that for a word? It's almost as bad as conciliation. It's reasonably practicable for the employer to do that. And then we have in BC that all employers have to provide protections for all known or reasonably foreseeable health and safety hazards. So as an employer, as long as you have taken a look at the circumstances that we're facing now with the COVID lens, and you have carefully evaluated what those risks might be, and you have provided the necessary tools and equipment, you've altered the way the work is done, you've made all of those changes to the workplace and trained people appropriately, that is how you are ensuring you're meeting your obligations under the legislation. So I'm going to hand this now over to Simon, who's going to help answer some questions for us about the application of the law in occupational health and safety law in cases related to COVID.
Thanks, Kelly. I think we should say I'm going to attempt to answer because like in a lot of things in the law, it's very gray, especially with COVID. A lot of these questions we can attempt to give some answers today, but I suspect that that's going to change over the next few weeks and months. And specifically around my thought that the government is probably going to have to step in and I mean, just my opinion that it would be very helpful if the government was to step in and to create some sort of legislation to assist employers in answering some of these difficult questions, which we're going to chat about in the next few minutes. Okay, so the slide that I'm on here is, can employers require employees to undergo mandatory testing? And there's only two elements of this. One would be in the union setting versus the non-union setting. And so what we've set out here is a case from Ontario, just a recent case, dealing with a care home. This is a unionized environment. And in this case, the labor arbitrator decided that asking the employees or unionized employees to be tested with a nasal swab every 2 weeks was allowed. The union had grieved that, saying that it was too in a sort of an invasive a process. But as I say, it was upheld. And I thought I would just read quickly just a quick quote from that decision. The arbitrator says, in my view, when one weighs the intrusiveness of the test, a swab up your nose every 14 days against the problem to be addressed, which is preventing the spread of COVID in this long-term home, the policy is a reasonable one. While the home had not had an outbreak, I agree entirely with the employer that, given the seriousness of an outbreak, waiting to act until that happens is not a reasonable option. So in that particular circumstance, it was allowed. Now, I can see in others, it wouldn't. If we step out of the union context and we look at, for instance, a restaurant, would it be acceptable for a restaurant owner to require that all staff are to get this swab up their nose every 2 weeks? I don't know the answer to that. I think it's, I would say that the answer is no. I haven't heard of any examples of that. I think we understand in these care homes that there's a higher degree of acceptance for that kind of invasive request. But if, in our case in BC, Dr. Bonnie Henry is saying that there's certain things that needs to happen in a restaurant, such as only 6 people at a table, have to be spaced apart, everyone has to wear masks. As long as you're sort of fulfilling those requirements, then I think that it would not be acceptable for a restaurant owner to ask for mandatory testing in that particular circumstance. Okay, let's move to the next slide. So the next one is, there we go, can employers require that employees wear masks, gloves, and shields? And I think the answer we've all sort of seen in our day-to-day life is that the answer is yes. If I just go into a London Drugs here in Vancouver, I see everyone wearing masks. That has been mandated by our provincial health officer. There was even before she came out and decided that it was mandatory that everyone wear masks, most employers were requiring their employees to wear masks. I also see at London Drugs people wearing shields as well. So, and I haven't seen a lot of people wearing gloves, but I think that if an employer required that would be acceptable, except if somebody had an allergy. Some people have an allergy to latex, and the employer would have to provide gloves that were non-latex. But I know here at our law firm, we've got a safety protocol in place, and everyone is required to wear masks when they're not in their office. So that appears to be generally accepted, and I would say that employers can definitely ask their employees to wear PPE to that extent. I don't think I'd be able to get the lawyers here to be wearing full gowns or anything like that. It wouldn't make any sense. But the wearing of masks does seem to be preventing the transmission of the virus. And actually, one quick example: we had a situation where one of our lawyers met with a client in person for 45 minutes. Both the lawyer and the client followed protocol, which was that they wore the masks, that the client was not to go in any other place in the office, that the office was wiped down after the client left. Anyway, a few days later, the client called and said that he had been found to be COVID positive, and he had COVID when they were having that meeting. So it showed that by wearing the masks and having some social or distancing, that the lawyer in this question did not get COVID, and nor did anyone else in the law firm. So that was interesting. Okay, next up is a poll. So this poll is, do you think, and this is leading to the next topic, which is, do you think vaccines should be mandatory for employees? So I'll give you a few minutes to answer that. Okay, we'll finish up. Well, let's see the answers.
Okay, I'm back to read the answers. The number one at 68% was it depends on the type of work. The second answer at 18% absolutely, 9% definitely not, and 5% of I'm not sure. So there we go, and we'll put it back to you, Simon, and we're going to ask you, Kelly, I think you're in charge of pressing the play button. You did it. Perfect. Thank you.
Okay, next slide. Can employers require employees to be vaccinated? So this is a fascinating topic, and there is no clear answer on this at the moment. I mean, we'll see how the 2021 progresses, but I shouldn't say there isn't a clear answer. I think the clear answer is, for the most part, the answer is no. There's no current legislation requiring that. Governments at all levels are at least currently saying that taking the vaccine is voluntary. Oh, there we go. We're back.
Yeah. Sorry about that. I don't know what keeps.
That's okay. I'll let you know if it happens again. The vaccine supply is quite limited right now, so it's certainly at this point it's very difficult to mandate that employees receive the vaccination. I mean, here in BC, you have to be 90 or over to be booking an appointment for a vaccine. So we're a ways away from it being generally available. Another interesting part about the vaccine is we're not quite clear yet on whether it's going to stop transmission. So you can get the vaccine and it can reduce the amount of sickness that you might have. I think the idea is that it's keeping people out of the hospital, out of the ICU, and certainly keeping them from dying for the most part. But we're not clear yet on just because someone has the vaccine, whether when they come into the office, they'll be less likely to transmit COVID that they might be carrying. I believe the idea is that, I guess it's called shedding the virus. I think that there'll be less virus to shed. That's my sense of it right now. That if you do get the vaccine, you're going to be less likely to give it to others. But I think we're a ways away from being able to say that, you going into the workplace, having been vaccinated, means that you can't give it to others who are not vaccinated. Okay, next up was case law. There's really nothing yet on this idea of mandatory vaccination. And so we'll be watching for that into the rest of this year and into 2022. Some of the things that lawyers do is they compare this idea about mandatory vaccinations to cases dealing with the requirement that people get the flu vaccine. Certainly here at Kent Employment Law, I don't have the right to require anyone to get the flu vaccine. But as the poll points out, there will be times where that kind of requirement may be justifiable. And the case law around the flu cases points to sort of three areas that we need to think about when determining the reasonableness of that request. One would be your expert evidence, but that just means there had to be evidence that by requiring vaccination, that's going to reduce the risk of transmission. So for instance, you're working in a long-term care home, you get vaccinated, well, will the mandatory requirement of vaccination prevent the transmission of the virus to, say, people that aren't vaccinated? Then we have to always sort of balance the rights of the employee versus the duty to protect that the employer has, duty to protect other employees. And Kelly was setting that out in the last few slides. There's a duty that employers have to protect their employees from harm. And, you know, in situations where wearing a mask or social distancing is not going to protect your staff, perhaps it is going to be required that people who are working in the workplace in a situation like that, it may be mandatory to get a vaccination. And then finally, there's evidence of coercion. So in sort of determining whether vaccination would be required, you want to look at you know, are people able in the workplace to make a free choice about whether to get the vaccination or not, or are they just concerned about potentially losing their job and in order to sort of to take the vaccination in order to prevent losing their job? Okay, let's jump to the next slide. Okay, what happens if an employee refuses to work because of COVID? So there's different angles here that one could take. So from an occupational health and safety perspective, we've set out these sort of 7 steps that would happen. If an employee is concerned about working because of COVID, potential COVID exposure or COVID concerns in the workplace, the worker is to notify his or her supervisor. Then the supervisor would investigate and correct the problem, or will disagree that there is an issue. If the worker was to remain unsatisfied, they could file a complaint with occupational health and safety, which an OHS officer would investigate. The worker would be sent home or given other work, and there'd be no reprisals during that investigation. An employer may approach a replacement worker to assist, and then an officer would write a decision and may order corrective decision or action. Now, I have not actually dealt with that process at all in my work. What I get are calls from employers saying, hey, you know, we've got this individual, let's call him John. He feels uncomfortable coming to the workplace. What do? We need him to be doing his job. He can't do it from home. We need him here on the ground of the workplace. And then my general answer, and of course these things are very fact specific, but my general answer is, well, as long as the employer is following the directions of all levels of government that have anything to say about protecting your employees from COVID exposure, then it would appear that John needs to come to the office. And again, it's very fact specific, but there have been situations where an individual just says, yeah, I'm not coming in. I just don't like this whole COVID thing. I'm going to stay home. And if the workplace is set up such that if John went in, he would be protected, at least according to our provincial health officer, he would, then he needs to come in. And I have to have a direct conversation with the employer and say, I think in this circumstance, you could take the position that John not coming in is really an abandonment of his position, and you could end the employment relationship, even without paying any severance. So, of course, I don't want that to happen because this is a very unique situation. COVID has brought about a real challenge, you know, in the relationship between employer and employee. So I try very hard to steer the employer away from such a you know, draconian measure, so to speak. But sometimes it is possible, it is necessary. So I'll leave that there. Okay, next slide. What will OHS consider when determining if a refusal related to COVID is reasonable? They'll look at things like, what's the presence of the virus in the workplace? Is there a likelihood of, for this complaining individual to encounter an infected person? What's the risk of transmission within the workplace? What are the preventive measures that the employer has in place? It'll be comparing those to the public health guidelines. It'll look at the availability of a vaccine for those individuals that are in the workplace, and impact of vaccine on the risk levels of that workplace. So it's the same kind of analysis that I would take as a lawyer for an employer or an employee in determining whether it's reasonable for the employee not to come into the office. Because of course, someone like John could, in a non-union setting, could potentially call an employment lawyer and say, I feel very uncomfortable about going to work. And my employer is saying, if I don't come into the office, then I'm going to be taken to have abandoned my job and essentially I'm fired. So I could get involved at that point by writing a letter to the employer and trying to, almost like acting like a shop steward on behalf of the employee to try to find some sort of resolution so that the person doesn't lose their job. Or alternatively, if they do lose their job, that they're paid some severance as a result. Okay, next slide. And can employers discipline employees who do not follow COVID protocols? So there are sort of two cases that are being sort of sent around between law firms about on the union side of things, where individuals have been or employees have been let go and usually and upheld in a grievance. And it's all about misleading the employer. So of course, no one's going to get fired because they got COVID, but it's if you, for instance, one of the cases, an individual, it was very clear, the employer had very clear policies about what happens if you suspect you might have COVID. If you have any symptoms, you're supposed to stay home. And in this one particular case, this individual suspected they might have COVID, went and got a test, and as they waited for the results, came into work. And so that was found to be something, the behavior that was incompatible with the continued employment. And so the arbitrator upheld the dismissal. So that's on the union side. On the non-union side, yeah, for sure. I think that if I have an employer that calls me up and is telling me about an employee that's not following the COVID protocols that are set out by law now through our provincial health officer, I'd say that they would have grounds for their dismissal. Again, it's fact specific, as lawyers love to say, but in a situation where it's just an outright, I don't believe in COVID, I'm not wearing a mask, then that would be a dismissal for cause. And I would suggest, I'd probably suggest that a little bit of severance was paid out, but you as an employer could take the position that you had cause for the person's dismissal. So back to you, Kelly.
Thank you. I just, following up just a little bit on what you've been saying, Simon, I think a lot of times we see sort of a lot of these issues getting worked out in the unionized settings because the grievance mechanisms are so readily available and they tend to be a little bit quicker than it is for non-unionized employees. So we see the thinking and the analysis coming from that level, which is why you're seeing us refer to arbitration cases a little bit more frequently than we are non-union type cases, and they bubble up from there, and then that rationale gets used as they move forward through the system. And as time goes on, we'll start to see a lot more cases, I think, being resolved elsewhere as well. So the next thing we're actually going to talk about is workers' compensation. So this is another area where people have a lot of questions around whether or what happens when someone might have contracted COVID from the workplace. And so just to give a little bit of brief background about workers' compensation, it's basically an employer-funded insurance scheme. So employers pay into the workers' compensation scheme just like you would for any other type of insurance, car insurance that you have. House insurance, where you pay your fees and the insurance protects you should an incident occur. So it works the same way for workers' compensation. Not all employers have to pay for insurance through workers' compensation. There are exceptions in each province that are somewhat unique, but in order, most large and high-risk employers certainly are required to provide WCB to their employees. So essentially what happens is it's a no-fault compensation system where if an employee gets injured or sick while at work, then workers' compensation supports that employee. Their salary is paid for, their health care follow-up is paid for through that insurance scheme. The exchange for that really is there's a bit of a trade-off. So in order to have that compensation and to go that workers' compensation scheme, the trade-off is that employees have no right then to sue their employer for workplace-related injuries or illnesses. The really big question that often is asked, and I think the public is less aware of these fine distinctions, but the issues that often arise in workers' compensation cases are whether or not the disability has actually been caused by or exacerbated by work. So if it has been, that is normally compensable, but sometimes that's really hard to tell the difference, right? Whether something's an occupational or a non-occupational injury. And if you think about stress-related injuries, for example, you may have been doing the same kind of job for multiple employers, and over time you have put stress because you've been on a part of your body because you know it might be a repetitive strain kind of an injury, and that injury, it's very hard to distinguish at what point it arose and at what point it becomes compensable, or whether or not it arose because of the workplace. You shoveled your, you've got back pain, a back injury, you can't work, or did it happen because of what you do in your job? Because all of us are sitting in chairs, I think, more than we used to be because of COVID. Did it occur because of that, or did it occur because you shoveled your driveway the week before? And so teasing out those distinctions is often where we see disputes around workers' compensation, whether or not someone is eligible to get it, to get compensation. So there are certainly presumption for certain occupations and health conditions. So there are certain health conditions related to having worked in a coal mine, and that's automatically assumed to be compensable if the person has a particular type of cancer related to coal dust. There is a presumption in most provinces now with respect to stress or post-traumatic stress disorder related to first responders. So people, police, firefighters, paramedics, those on the front lines, often there's a presumption related to, if they have that condition, it is assumed to have been related to the occupation because the occupation is inherently stressful or high risk. So that is basically what workers' compensation is about. And employers are required to report, and it affects their rating. So sometimes they're a little uncomfortable or don't want to report when illnesses and injuries come, because then their insurance rates basically go up, like it would for your home insurance or your car insurance if you have an accident. So they are required to report, but I think that there are sometimes questions around when they, you know, sometimes things go a little underground and they choose not to report, let's put it that way, if they can avoid it because of the impact on their, you know, on their rates. So with respect to COVID, workers' compensation, both in Alberta and BC, and I didn't pull up Ontario or legislation from other provinces, but I thought I'd look at these. It's essentially what workers' compensation is saying is that if the type of work that a person is engaged in, if their employment creates an additional risk of contracting COVID that's greater than what an ordinary exposure would be for someone who's in the public at large, then that is compensable. So if the employment involves exposure to the source of an infection, the nature of employment is the cause of the condition, or creates greater risk of exposure for the worker. So those are the kind of situations where that presumption will be made with respect to compensability, or whether or not someone is eligible at compensation for COVID. And I think that we are not seeing the cases, so many cases just yet, but I think that this is where we're going to see a lot of activity as well, whether or not COVID is related to the workplace. I think we're going to see some legal cases coming forward here. So I'm going to hand it back over to Simon to talk about the human rights side.
Okay, great. Thanks, Kelly. Okay, so just a quick summary on human rights. So in both provinces, we've got a human rights code, and there's protection against certain forms of discrimination. We don't have the actual discrimination ground of creed in BC. I guess there is in Alberta, and I actually had to look up creed last night and what that is. So yeah, I know it's been a while. So anyways, the whole issue around human rights, just to summarize it, is imagine that someone has a type of a medical condition which doesn't allow them to, say, wear a mask or to be vaccinated. It could be a medical condition, it could be a religious reason, and we're trying to balance that worker's right to say express their religious freedoms versus the employer's right to require that a mask be worn or that a vaccination be had. So if you've got a situation, if you're an employer and you say everyone needs to wear a mask, and one of the employees has a medical condition which prevents them from wearing a mask, then you would be required to accommodate that need up to the point of undue hardship. So, and that's quite a simple example. I guess the accommodation part of it in a situation like that would be, could that person work in an office, an enclosed office like I'm in right now, while everyone else was wearing a mask outside of the office? Or could that person do their work from home, as an example? That would be examples of pretty common accommodation for that. It gets a little more complicated around the vaccination issue. So, and I don't have any fact scenarios in mind for this, but I can imagine there'll be maybe the long-term care homes, but at some point when vaccinations are available to everyone, and then you have a situation where a person says, you know, in Alberta, like I said, in either province, they could say, I don't want to get the vaccination on religious grounds. You know, what is an employer to do with that? If it's a situation where they really need everybody in the organization to get a vaccination, and there's no reasonable accommodation to the point of hardship, the person can't do their job at home, for instance. It wouldn't be sufficient if the person wore a mask. And again, very, very fact specific here. But at some point in this analysis on human rights, the employer's needs will trump the employee's right to, in that case, not to have a vaccination. So it's like, and this is why Kelly has rightly put a scale as an icon or as a picture, because in all of these situations, it's an analysis between what the employer's needs are versus the rights of the employee. Okay, so next slide. So as we look at you know, this whole test about whether we get to undue hardship, here is the kind of information that an employer would be allowed to seek from an employee as it determines whether the request to, for instance, not be vaccinated or not wear a mask would rise to the level of an undue hardship. So the employer can ask for medical information confirming that a health condition exists. So obviously just having an employee come in and say, you know, this wearing a mask is going to causing some eczema on my face. You're going to want some medical evidence around that, and not just taking the employee's word for it. You can ask for a medical verification of a negative COVID test. You can ask for a medical verification that a person is could be seriously impacted by having a vaccination. Sometimes, you know, some of the things that go into making up a vaccination can cause an allergic reaction, as well. Some immune compromised individuals may not be able to be vaccinated. Again, you would need some medical evidence around that if you're an employer. The employer can ask about whether you've got existing immunity, whether you've had COVID before. I mean, one of the things an employee could say is, hey, I don't need to get the vaccine because I've already had COVID and therefore I've got antibodies. Well, it's fine for the employer to ask for proof of that then, if that's the position that's being put forward by the employee. If someone is saying they've got a religious prohibition around getting vaccinated or wearing a mask or other type of PPE, then the employer is allowed to get some information around that, some sort of proof. I don't know what that would be, but I'm sure it would have to be more than just the individual saying that that's the way, that's the dictates of their religion. looking into the basis for knowledge, beliefs, or convictions, and that's had to do, I think, more with creed, and evidence of caregiving responsibilities. Sometimes under the heading of family status, one can argue that they're being discriminated against because of the makeup of their family and maybe with caregiving responsibilities being a part of that. So if that's the sort of the angle that an employee is taking, there's going to have to be evidence around that for the employer. Okay, next slide. Things to keep in mind about human rights in COVID are that there can't be any negative treatment of employees who have or are perceived to have COVID. So I think we've seen some pretty good examples of that in the press so far, but any employer who is disciplining or dismissing because someone's got COVID that's going to be a problem for them. That's going to be a violation of the human rights. Absence policies should not negatively affect employees who cannot work because of COVID. So it would, it's not fair to say if you're away from work for 4 days in a row, you will be dismissed or something like that. There's all kinds of draconian sick day plans that that employers have, and of course this is different. Having COVID, you might not even have symptoms, but having to actually be away for 10 to 14 days on a quarantine because that's required by the provincial health officer. That's not something that you should be negatively impacted on again. No discipline or termination because employees are required to isolate. I just covered that. Accommodate, employers should be working as hard as they can to accommodate caregiving responsibilities, offering flexible options where possible, and don't, I guess as an employer, don't ask for too much information because we don't want to burden an already overburdened medical system. So why ask for a 7-page medical questionnaire when just a quick note from a GP will do? So that's the end of human rights. And then back to you, Kelly.
Yeah, I think there is certainly a lot of question around that last point right now with respect to the burden on the medical system and asking an employee to go into a doctor's office to verify something when it's difficult to get an appointment at all, and they might not be able to get there, and telehealth might not be suitable. So there's a lot of times that the existing policies that employers have might during this period of time be overly burdensome for the medical system. Sometimes they're overly burdensome for the medical system anyway, but worse now. Okay, so the next thing we're going to talk about, actually, oh, did I go too fast? No, I didn't. Is thinking about policy. So we've covered all of the really key pieces of legislation that impact how employers should be organizing things in their workplace, the policies and procedures that they should develop. We've covered the thing, what employees should be aware of as well with respect to work and attending work, what you have to wear for personal protective equipment, and that kind of thing, and what your rights and responsibilities are on both sides of the table. So when we're thinking about developing COVID-related policies and procedures in a workplace, really it is very much tied to the idea of hazard assessment and control that's very familiar to those of you in HR or in occupational health and safety. You're still following through with all of these steps that you would take, and you're just doing it with a particular COVID lens. So you're looking at the types of work that exists. We're doing that hazard assessment first, and we're sort of doing a job demands analysis, looking at each type of activity that's taking place in your work, on your work site or in your workplace, and assessing the level of risk of exposure for COVID, right? So you're kind of doing a job demands analysis, but you also need to be thinking about assessing psychological demands and safety around potential for violence. So you're looking at those activities that are occurring for each job category and assessing it with respect to exposure to COVID, with respect to a change in psychological demands, and also with respect to the potential for violence. And those are really some key things that you should be thinking about a little bit differently than you might have been thinking about before. So you're identifying what those specific hazards might be in those particular roles in the organization, then prioritizing and analyzing those, which is typical for any kind of hazard assessment system, and assigning some kind of measure of the risk that's associated with it. So how much exposure to the public might there be? Obviously, the risk of COVID is much higher for someone in healthcare than it is in a lot of other occupations. There's almost no risk for someone like me right now. I sit at home in my office. I don't go to the university at all anymore because we're just not, there's not a need for us to be there. Our processes, our meetings, everything can occur from home. So for me, that particular hazard is very low. We have, then once you've done that prioritization so that you're making sure that you are addressing that in the different job categories, you implement the appropriate controls. Now, obviously, we know COVID is not going anywhere. So the top of that triangle, that elimination in blue there, is not going to happen. You can probably substitute certain types of work. You can implement engineering controls with screens and that type of thing. And then there are administrative controls, which are things like the social distancing, limiting when people can have meetings and when they can't have meetings, limiting the movement of people in hallways, and then of course PPE at the very tip, which is the last thing that we try to implement, but it's probably the thing we're seeing the most of, are those two types of controls in red that are in that pyramid there, the administrative controls and the personal protective equipment. That's typically what most employers are utilizing to manage COVID in their workplaces. Once you have developed all of those and identified the hazards and developed and implemented those control systems, you need to make sure that you're communicating what the hazards are to your employees and teaching them how to use the equipment that you're asking them to use, because a lot of people are using things that they might not have had to use previously. And of course, as always, we want to be evaluating the effectiveness. So you're keeping an eye. Well, I see my screen changed again. You're keeping an eye on your outcomes and whether or not people have actually been, what your sickness or exposure rates are. So really, in terms of your policy, some really key things to think about, I think, are the hazard assessment. Like I said, assessing the violence and psychological risk that might be different now, and putting in place different methods to deal with those. Consulting with your employees and your unions in the processes and developing those, making sure you're giving as much notice possible of any changes to current practices. Of course, last March that was not possible to give much notice for most people, but try to give the notice now that we have a little more experience with COVID. We can do that. Providing the equipment and training people. Vaccines. So we've talked here today about mandatory vaccines, but we haven't really talked about the idea of offering incentives. So employers might want to consider offering vaccine incentives and to encourage their employees to get vaccinations if it's a concern in their particular workplace. And then, of course, we also haven't touched much on the pay side of things. So we know when, if an employee is being quarantined or, has to, a lot of organizations, especially smaller organizations, have had to lay off employees. And so there are certain subsidies that are available, and they seem to change on a pretty regular basis from both the federal and provincial governments. But if as an employer you are large enough and able to either supplement or fill in gaps without affecting someone's eligibility for those subsidies, I certainly encourage employers that are able to do that to go ahead and take that responsibility if they can. And then, really thinking about those privacy considerations. It's because everyone talks about COVID so regularly and frequently in And it's sort of the constant in every news story, and I think in every workplace there's a lot of water cooler conversation. Thinking about that privacy side of the house is really important as well. The information that you might be gathering from employees, those who may or may not have gotten vaccines, if that's something that is occurring in your workplace, that kind of information is private. So having appropriate protections in place for that medical information that you might be requesting or requiring is crucial as well.
Hey, Kelly, I just got a question.
I think,
Kelly, I've got a question for you.
Yeah.
So I've heard of these situations where, you know, you've got, let's say that it's a call center or some situation where there's a bunch of people together in a workplace, and then someone gets COVID. I've heard of employers feeling that they can't divulge the name of the person who got COVID to the other workers, citing privacy concerns, which I thought was a bit odd, because if I'm sitting in this area, I want to know whether, you know, John, who I actually, you know, was sitting beside, had COVID, or, you know, he and I had to go and do a project together. We're both wearing masks, but I still would like to know that. So how do you balance those two? The privacy rights of John, my interest in knowing who has COVID.
Right. So there are a couple of things that I think can help support that particular circumstance. It is private information of the employee that has been diagnosed with COVID, and we do know that there has been some backlash against employees who have been diagnosed with COVID. At least anecdotally, we know that that's occurring in some workplaces. So protecting that person's privacy is absolutely crucial. But what employers can do is indicate that an employee within a particular space has tested positive, and where they've been and on what days. Can people figure it out sometimes from that? Quite probably, quite possibly. The other side of that, so they don't name the person specifically, but they do identify the location that that person was in, and let employees know that there has been someone who's tested positive with COVID in that general vicinity on certain days. And then the other piece is really part of the provincial response, which is that it's the system of calling people who have the key contacts or close contacts of people who have been exposed. Those people will be contacted by Alberta Health Services with the contact tracing system. So reassuring employees that if they've had a close exposure to that person, that they will be contacted is the appropriate thing to do. Does that prevent the water cooler talk entirely? Does it prevent people from figuring out who it might be? Absolutely not. It does, I think, provide the employer with a way of letting people know about the fact that there was a COVID presence in the workplace, and allow people to respond in that way.
That sounds good.
Would you agree?
I guess one option would be to ask the COVID positive person if they consent to, you know, his name being released to at least to the other employees. You know,
that's another way that
it actually reminds me of I've got 3 daughters, and I remember one of them went to nursery school, and I guess preschool it's called, and she came home with a big bite mark on her arm, and the school called and said, oh, she was bitten by another kid today, but we're not allowed to tell you who bit her. And so we just looked at her and said, who bit you, Lindsay? She said, Georgie bit me, right? Which I just thought, it just reminds me of this, because I think the water cooler talk, everyone's going to know who it is. So in a way, I know it's maybe funny for a lawyer to say this around privacy, but like, who are we kidding? Like, you know, at some point it becomes ridiculous, and we just have to say it was John. But I take your point, and it's certainly something that is pushing the limits of privacy, isn't it?
It is. It's a bit difficult, right? And certainly, I think often it's quite often that the people who have been diagnosed with COVID will share that information quite freely with their colleagues in the workplace, but it still has to be their choice, which I think is exactly what your solution proposes, is that you ask for their permission to share. It makes me also think, actually, though, of employers wanting diagnoses for various health conditions when they're being required to accommodate an employee for a health condition. Often an employer would like to have the diagnosis. They don't get the right to have that diagnosis. They get to know what the restrictions are, what the employee can and cannot do. And then, of course, that makes the employer more frustrated as they imagine or try to imagine what the diagnosis might be. But the actual diagnosis is really not necessary in order to accommodate to, in the same way that I think it's not entirely necessary for the rest of the employees to know the name of the person who has it, to ensure that the protection still is there and that people are made aware that a hazard was present at the workplace. So, okay, Simon didn't warn me he was going to ask me a question, so I'm, just thinking. Now I'm trying to think of a hard question for him, but I'll leave that to everybody else that's here. So this is really our last slide, and it's really summing up, I think, everything that we've been talking about. That really, dealing with COVID in the workplace is a balancing act. We're trying to balance safety of employees and public safety. We're trying to protect people's privacy, and we're trying to treat people as fairly as we can. And that, the employer needs to be able to run their organization to the best that they can, given the constraints that they're faced with as well. And employees have the right to know what hazards they're facing. So, enhancing the system, the existing hazard assessment and management systems that you already have is, I think, probably the best place to start. And really, I think for employers to be thinking about being, and co-workers, actually, employers and employees being sensitive to factors that might be affecting people outside of the workplace. A lot of students stay home from school, and parents are attempting to teach them or support them in their learning at home, and that's never happened before. We have people who might be providing elder care, and so they have an older parent who might be at high risk if they're exposed. All of those kinds of things, the level of stress that people are experiencing. There may be a spouse that's lost a job because of the circumstances around COVID. So there's a lot of things, and I think employers really, and employees, co-workers, if you can be sensitive to what those factors are and consider them and try to support as best we can, we provide the best workplaces that we possibly can for our employees and protect both physical and psychological safety. So that is the end of our presentation. And wow. I think now
Wow, that was some incredible information. I'm so glad that this webinar is going to go up on the WWI website, because I think it's going to be, it's critical that we're hearing this information, and such amazing information. Thank you so much. And I have moderated a number of these webinars, and I will tell you, I'm not too sure I've ever seen so many questions come in. We won't have time to answer them all, but I've tried to lump them in some kind of order or some kind of logic. And the first group of questions is around communication and between employers and employees. So like what level is it of legal rights that that employers have to communicate around legal rights, right? Like so around their legal rights to tell their employees, well, this is your legal right during COVID. So how much responsibility is on the employer to make sure that the employees are aware of their legal rights during COVID, and then also how they're impacted, right? Like so. So the question is that what around the changes in the employee legal rights mean and how they're impacted, right? And then of course taking into consideration that we're still continuing to work remotely. So how do you suggest that communication is effectively put out? So I've kind of squished 3 questions into one there. Good luck unpacking.
Thanks. So I think I'm going to just jump in with the start to say, from a legal perspective, really the occupational health and safety side is what you are required to provide information about. So you need to let people know what the hazards are, and you need to provide them information about their rights in the situation where they might encounter a hazard, and their responsibilities there as well. So that's where you need to actually provide the most information as an employer to your employees. You know, that's why we require, or the legislation requires posting information to, you know, at the work site typically. So in terms of the workers' compensation and human rights side of the house, you know, there's a little bit less of an obligation on the employer to actually provide that very detailed information to employees. But you know, pointing them towards their collective agreement or towards their you know, the human rights website, commission websites is appropriate, as I think, or workers' compensation. Certainly there's a duty also, I suppose, to communicate regarding the processes if they do get injured or ill in the workplace. Yeah, I'll stop there. Simon, do you want to jump in?
I think that's great, Kelly. That's exactly what I would have said. You know, on the side of things around, we talked about earlier about abandoning jobs and some of the stuff that we call the common law. The employers don't have any responsibility to educate their employees around some of those COVID-related issues. Again, severance, things like this concept called constructive dismissal, where you know, the employer may change a fundamental term of an employment agreement, and that could flow from something to do with COVID. You know, the employee could take the position that they've been fired from their position because of something COVID related, some sort of change to their position. But no employer is going to get involved in educating an employee around that. Usually what happens is the employees go online, find this phrase constructive dismissal, and then call a lawyer. So employment lawyers have never been busier. That's true on both the management and the employee side. We are just completely run off our feet across the country. I could work 16 hours a day if I wanted to, just because it sometimes feels like the world is falling apart from an employment perspective. But of course, we as lawyers, we just see the negative. Like, no one ever calls me and says, "Hey, Simon, everything's going great today in the workplace. You know, everyone's getting along, and this COVID thing is really easy." Really, what's happening is people are falling apart. Like, literally falling apart. Like, the mental health aspects of COVID are very serious. I've got employer clients who have, you know, their entire workforce at home, and people who were, let's use the term fragile before this thing started, are being ripped apart. All kinds of substance abuse issues, mental health issues. You know, what do you do as an employer when you send someone home and then they just never contact you again? Like, what do you do? You know, these are the kinds of questions I'm having to deal with. You know, one of my employer clients actually had to send the police over to a person's home to do a what's it called, a welfare check.
Yeah.
You know, and in this case, and just to sort of, I know we're kind of going on a bit of a tangent there, but you know, some of these employers will have policies around wellness that you know, they will encourage the employees to read. So that part of it is like, you know, what do we have here as far as an employer, as far as EAP goes, right? As far as sick days, as far as what happens when you exhaust your sick days. Tell me about your short-term disability policies, your long-term disability policies. When people are really suffering, one of the great things that employers can do is put together almost like a booklet about how we can support you through this time.
That's excellent. And this is, and I know that you've mentioned one website already, Kelly, but I'm wondering, are there other resources that are available for employees? I know that, Simon, you said, Dr. Google, right? And in this case, it would be lawyer Google. But are there other areas that you can think of, or maybe even we can, maybe not off the top of your heads, but maybe we could collect that and push it out through the WWI website. That would be great. Along the same lines, we're still on the same lines of this, but can you share any real work examples of a time when an employee was unaware of their legal rights during the pandemic, and what impact did that have on the employee and the employer?
Yeah, I'll talk about layoffs. So what's been really fascinating about COVID is this idea that everyone jumped on the layoff bandwagon. So, and I'm talking from a non-union perspective because I don't practice union law at all. So I'm completely non-union. So that's why Kelly and I are actually a good balance, because she's got so much experience on that side of things. And of course, the reason that I don't do a lot of that work is because the union owns the problem, right? They own the grievance. So an employee has decided, if they're part of a union, they're part of a collective agreement, and there's a process for dealing with disputes, and the union has its own lawyers. So to call me is to do so in a non-union context. So what happened when COVID hit was employers started freaking out, me included, and I didn't, but other employers just laid people off. And within the law, there's really no such thing as a layoff in the common law. You are entering into a contract with an employer to do work, and you get paid for that work. And if that work is no longer available, you've been fired, and you're entitled to severance. But we sort of suspended that as a concept in employment law, and people were just forced off on layoff. Now, there are times where layoffs are fine. So if, for instance, if I was to say to somebody here, hey, you know, Janet, we're going to lay you off, is that okay? Meaning implied that this is going to be sort of a short term, you going home and not working, potentially collecting CERB or EI. If that person consents, then that's great. If it's was in their employment agreement that was a potential thing that I could do as an employer, that would be fine. And if it's if they're in a kind of an occupation in which it's standard for a person to be laid off, you know, because of, say, breakup for logging or in the fishing industry or something like that, then that would make sense. Or the ski industry is a good example. But this is a long way of getting to your point or your question, Maureen, which is the one thing I don't think that employees understood was that you can't be laid off, except for those 3 examples I gave. And, you know, within a few days, you could just write to the employer and say, hey, you fired me, I want severance. It was this idea that it was permissible to be laid off. And I understand why, because if you go back to March and April, like I was very worried. I was very worried what was going to happen. And I know anyone running a business had to be worried, unless you were, you know, making hot tubs, which, you know, that went through the roof, right? There's certain things, or you're making masks, you were great. But for the majority of us, we were very concerned, and I understand why everyone ran to the whole layoff situation. But the reality was, and now it's all sort of coming home to roost now, where the employees are, we all now are sort of used to COVID, and we see that it's not going to like decimate our entire population. And now all of a sudden, employees are strong again and saying, hey, you know, when you laid me off in March, actually you weren't allowed to do that, and I want severance from that date onward. So that was one area that I thought people needed a little more education on.
That's excellent. Thank you. Can we, I'll go on to the next question if that's okay. I think that you've actually answered this during your presentation, but just in case. During the pandemic, what are my legal rights as an employee in terms of returning to the office? Am I obliged to return to the office even if I don't feel safe to do so?
So, yeah.
Kelly.
Yes, I'll take this one. So the answer is that if your employer has put in place appropriate protections for you at the workplace, yes, they can require that you come back to work. And that if provided they're following public health guidelines with respect to the restrictions around COVID, then yes, you can be required to go back.
Yeah, I thought that I heard you say that during the presentation, but I thought, oh, just in case. Thank you. What about, and I know, Simon, you had talked about a little bit about sick leave, but either one of you, can you comment on the legal obligations for sick leave right now? What sick leave must be paid, which is versus not paid? For example, someone testing positive versus somebody experiencing symptoms, and yeah, I'll leave it there.
Kelly, I might get this wrong, so jump in. I believe on the non-union side, there is no requirement that an employer pay for sick leave. So obviously there's a requirement that a person stay home, but the minute the person walks out the door and is unable to work, unless it's in a contract that sick leave is provided as part of the employment agreement, the employer does not have to pay a single cent. The person could take vacation if they wanted, or else they're going to have to go on an essentially what it is an unpaid leave. Do I have that right, Kelly?
Yeah, and I think it's very unique for each workplace, because often in a unionized environment, you will see sick leave embedded in the collective agreement, where the employer is required to pay, you know, after 3 days or after 5 days. There's a short-term disability and a long-term disability, and those intersect with it as well. So if there is if you have a short-term disability plan, okay, or a provider, an insurance provider for that side of things, that's not typically workers' compensation. That is a separate issue, but private insurance, they will have, those rules will be dependent on what's within, you know, what the agreement is with that particular provider. So quite often you have kind of the first 2 weeks where there is no coverage, or the employer covers it, but that is based on what has already been negotiated and is in your individual employment contract, or employer policy in some way, or perhaps in a collective agreement. So that first couple, and then often short-term disability kicks in after that first couple of weeks. But whether or not that the first 2 weeks are covered is really dependent on what your particular employment situation is.
Excellent, thank you. How would either of you suggest unsafe working conditions should be reported, from both the perspective of the employer not following COVID-19 protocols and from an employee not following COVID-19 protocols?
That's more of a Kelly question, but I would say that if an employer or if an employee asked me that, I'd say that's an automatic report to WorkSafe here in BC.
Same for you, Kelly?
You know, certainly if it's, I would say if it's the employer, first you go to your supervisor, okay? As is required, you go to your supervisor, and if they don't agree to change it, if you're reporting it, that's part of your duty as an employee to report an unsafe work condition. So you go to your supervisor disagrees. So those steps that we followed there, if it's the employer who's not doing it, you know, providing the protection, and then, because I think you really want to try and give the employer the opportunity. Now, maybe this particular person asking this has already tried that. If it's a coworker, I still would go to the supervisor first. If there's a person who is refusing to follow, so someone who's not wearing masks when they ought to be, that's such a hard thing for employees, right? It's terribly awkward. Do I tell on my coworker? But this is one of those circumstances where I think you must report it. And if your employer doesn't do anything about it, then WorkSafe BC or OHS Alberta, okay, or Ontario, or province you're in.
Right. And that goes back to your first point, how you opened the presentation, Kelly, about know your jurisdictions, right? Know where your jurisdictions are and who is responsible for what.
Right, and a lot of organizations may have operations in more than one jurisdiction. So if it's a large company, they might have an operation in British Columbia that they have to follow the rules for workers there, and another one in Ontario that they have to follow the rules for. But their HR department and legal department for those large organizations would know. It's usually the smaller ones that get confused and go to the Canada Labor Code for everything, when that's not necessarily what applies to their circumstance. So
right. Excellent. Okay, our next question, Simon and Kelly, do either of you have any suggestions on how to handle the delicate situation of an employee having a medical exemption from wearing a mask? How can we fairly handle that employee's needs while still considering the needs of other employees? This is the balance, right? That's the scale that you had.
Yeah. Well, let's just put it in if that was to happen at Kent employment law, you know, we could accommodate that. We would we would just require that the person worked in a closed office, that they kept their door closed, and that they left from a different, or came in and left through a less used entrance, and require that they not go and talk to somebody else. So it's a little bit isolating, or they just have to work from home. It's tough because, I really want people to come back to the office, but in that circumstance, if somebody couldn't wear a mask, what I would do is I would talk to other people I'd get consent first, Kelly. I would get consent to talk to the other people in the business, in the law firm, about this particular person's needs. And because it's all about comfort. I don't want to be the one to mandate something and then everyone thinks, wow, that Simon's such a jerk. I feel really unsafe now. So I have found through this whole year process that it's all about transparency and inclusion. And if we can all work together for this sort of greater good, then great. Now, of course, if this individual says, I don't want people to know that I've got this medical issue, then I'm going to want to have them stay at home. But I've had lots of employers call me, and I don't know how I would suggest they handle it. If you've got an employee who's working at the front desk and greeting individuals, greeting customers, I don't, one of those shields is not enough. I see those guys running around with those shields. I think that's not doing anything. Maybe I'm wrong, but it just doesn't feel safe, right? And a lot of the safety is around perception of safety as well. Mm-hmm. So yeah, it's a very, very fact specific, but it's an interesting job being an employment lawyer right now, because I do get these calls from employers, and they just, like you, Maureen, just throwing these questions at me, and my immediate reaction is, I think, oh man, I have no idea. But then of course that's not what I'm being paid to do, is to say I have no idea. So I try and work through it. What do you think, Kelly?
Yeah, I think I would agree with what you said. I'd be working through that hierarchy that I provided earlier of different ways of controlling hazards, right? So, which is exactly what you talked about without referring to my pretty colored triangle. Having the person move through the office in different ways. So separating that person in some way, using perhaps screens, not the face mask kind of shield, but the big screens and the face mask perhaps. That they're, having them work from home, that there are alternative ways. But I think one of the big things, at least from my perspective, as a supervisor, would also be to try to, I guess, address a cultural issue inside of the organization, and make sure that it's very clear that that you are following the rules for every individual person. And that there are some times when you are trying to accommodate specific needs, and those needs might be for a wide range of reasons. Mm-hmm. So not everybody is necessarily going to look the same. How we are protecting people isn't going to look the same for everyone. So getting that information out and that knowledge out, having those conversations about how you're trying to balance all of these things for different people, then maybe doesn't make that one person so different than everyone else. And that this is our general approach, sort of coming out with some communications around that, and having those conversations might be helpful, as well as what Simon suggested. And of course, always asking if you can just let people know.
So I think that we're right at the 2:30. Well, it's Toronto Eastern time, right at the 2:30 mark right now. And so I'm going to hand it back over to you, Yusra, but this has been extremely informative. So thank you both very much.
Thank you so much, Maureen and Kelly and Simon, for this extremely informative and engaging presentation on employee legal rights during COVID-19, and for raising some great points that we will be thinking about even after we leave this session for sure. A couple of reminders: the presentation is recorded and will be posted for free on our website along with the slides. If you are a WWI, VRA Canada, or CPHR Alberta member, you receive free certificates of attendance. Immediately following the webinar, you will be directed to the evaluation survey. We greatly appreciate your input on our webinars, as well as suggestions for future topic areas. All of our webinars are created for public access and supported by voluntary donations and members. Thank you again for your participation. It was our greatest pleasure to listen and learn from you, Kelly and Simon and Maureen. Thank you.
Thanks, everybody.